Okay, I'll go ahead and call then our final case for today. This case is from Wyandotte County. Case number 127026, Midwest Crane and Rigging, LLC et al. Versus Thang. And if council could please state your appearances.
May it please the court, Kurt Brock on behalf of the appellants Midwest Crane and Rigging, LLC and Brandon Weekly.
May it please the court, Atif Abdel Khalek appears on behalf of the appellee, Thang.
Okay, would appellant like to reserve time for rebuttal?
Yes, Your Honor. We would reserve 2 minutes.
Okay, we're ready to begin when you are.
Thank you, Your Honor. May it please the court. Midwest Crane is a small family-owned business. It employs union operators that operate heavy cranes that travel on our roads here in Kansas and in Missouri and some other states as well. On November 8th, 2016, Brandon Weekly was driving one of those self-propelled cranes northbound on I-635 over in Wyandotte County near Metropolitan Avenue. I-635, as the court may be aware, is a 3-lane highway northbound. It's an interstate highway. The crane weighs 76,000 pounds. It's a heavy object. If you're familiar with the area, I-635 northbound descends downhill from Gibbs Road towards Metropolitan Avenue. So we're on a downhill run. Brandon Weekly was descending that hill and approaching the Metropolitan intersection in the number 3 lane. Mr. Weekly encounters a vehicle being driven by the plaintiff in the underlying case, Thang, who's driving a car. He's also in the number 3 lane. He slows his vehicle in front of the crane and almost comes to a complete stop in front of the crane. And keep in mind, this is an interstate highway where the speed is 65 miles per hour maximum speed. The trial testimony was that no one was in front of Thang when he was slowing. Brandon Weekly sounds his air horn that the cab is equipped with. He locks up his brakes, but a collision occurs, unfortunately. 911 is called. Trooper Bees from the Kansas Highway Patrol responds to the scene, and Trooper Bees, after moving the vehicles off the highway, speaks to both parties. At the scene, Boo admits he slowed significantly in the 3rd lane. Trooper Bees records this statement in the report he prepared. Not surprisingly, Thang then files a lawsuit in 2017 seeking damages. Before that lawsuit is tried, he's deposed, and he testifies differently than what Trooper Bees told him or was told. Trial is initially set in August of 2022, and prior to trial, the plaintiff files several motions in limine, one to exclude the report prepared by Trooper Bees. The court granted that motion to exclude the report from evidence. Now, after the November 2016 collision that I just described, Boo was involved in another rear-end collision in February of 2017, within about 3 months from the first accident. Boo testified in his deposition he sustained injury and testified he couldn't tell whether the pain was from the first accident or the second accident. Midwest sought to introduce evidence of the second collision. Number 1, that it didn't cause his injuries, but number 2, evidence that he was a serial plaintiff. This was a second claim. The district court sustained the plaintiff's motion in limine and excluded that 3rd motion in limine. It did not allow evidence of the second accident to be told to the jury. The August 2022 trial was halted due to COVID. The trial began again fresh in April of 2023. Voir dire begins, and one of the jurors, in response to a question from the court, accuses me of doing something bad to his family. This is juror number 4 I'm talking about. It's done in front of the entire panel. I immediately moved for a mistrial and a new panel, which was denied. The case was tried, jury instructions were submitted, and several instructions were refused by the court. A jury verdict was entered, and this appeal has followed. I submit there are 3 general issues for consideration today. One, did the district court err in granting the plaintiff's motions in limine? Two, did the district court err in failing to declare a mistrial or seat a new panel? And the third issue, did the district court err in failing to properly instruct the jury? As to the first issue, we contend that the district court erred in granting the plaintiff's motion in limine. The first motion in limine sought to exclude Trooper B's accident report. We contend that was error. The report contains statements made by Thang Bu, which are inconsistent with not only the deposition testimony, but also Thang Bu's trial testimony. We contend that the report was admissible as a prior inconsistent statement under KSA 60-460A. We cite to the State versus Jeffrey case, a 2003 Court of Appeals case, to show that the report should have been admitted to show the discrepancies in witness testimony. Here, the report was being offered to show Thang Bu changed his testimony from the scene, what he told the trooper, to what he was testifying in his deposition and later at trial.
That came in anyway. That was fleshed out during testimony, was that he had made these inconsistent statements. So it's not as though the report left them in an all or nothing situation.
It came in a limited fashion. I would agree with that. But
the message communicated that he had made inconsistent statements.
Yes, the message was communicated, but no reference to the report was made or able to be made because the report was excluded.
Why does that matter? I mean, to me, the point is that he made inconsistent statements, whether it's written down on a report. I don't know why that makes a difference.
Well, I think it goes to obviously the credibility of the witness, Mr. Bu, and also it goes to the strength of those statements because he's clearly flip-flopped. Your point is correct. The point was made that he had made inconsistent statements, but we weren't able to show in the report where that statement was made.
Was the jury notified or were they otherwise made aware when the inconsistent statements were made?
As far as time of the statement?
Yes.
Yes.
So they knew that it was made in a report. They just didn't get to see the report.
Well, I don't know if we were not allowed to reference the report and it was not admitted into evidence.
I understand it wasn't admitted into evidence. You've
Right.
told us that 3 times now.
Right.
I'm just trying to get from you what was communicated to the jury.
I believe that the inconsistent statement, the fact he has made them, that was covered on cross-examination of Mr. Bu.
So his credibility, the questioning or the questionable nature of his credibility was made clear to the jury.
Well, again, I would argue that it probably wasn't because there's a statement made in the report itself that certainly would have assisted with that cross-examination, but we were not allowed to refer or use the report in that fashion.
I guess I'm looking at the transcript now. And the question, it looks like the trooper said, testified. He understood that he slowed down. And then there was a question to the trooper that says, based upon those stories at the scene, did you then prepare a report indicating the positions of the party? So it does appear that that information came in, that he told the trooper he slowed down and the report was. So I guess just piggybacking and not trying to beat a dead horse here, but it does appear that information came in. So where was the prejudice?
Well, I think the prejudice is twofold. Number one, I think the report should have been admitted into evidence. Number two, the court also precluded Trooper B's from testifying about what his opinion was about what contributed to the accident. He had an indication in the report of what he believed contributed to the accident, and that was Thang Bu slowing his vehicle to almost stop on an interstate highway.
He didn't witness the accident.
He did not. It was solely based on Thang Bu's statements.
So that would have been conjecture on the part of the officer. What contributes to the accident?
Well, I don't think it would be conjecture because the plaintiff, Thang Bu, admitted it, but later denied it at deposition and at trial. We believe that the evidence of the trooper should have been able to testify as to that, and KSA 6456A allows that evidence if the opinion is incidental to the witness' actual knowledge of the facts and circumstances. Here, clearly it was incidental because he based his findings on what Thang Bu told him.
That's not actual knowledge.
Well, it's actual knowledge of a statement of a witness, Mr. Boo.
I'm not certain that's what it's trying to communicate. Is your actual knowledge of what somebody else said about the incident?
Well, I think it's certainly an admission of a party opponent, Mr. Boo, that he later denied. So that there's at least two reasons why the report should have come in, at least with regard to the inconsistency of his statements and also the opinion of the trooper as to what contributed to cause this accident. So we would contend it was error to exclude that report. There was also a third motion in limine that I mentioned, that there was a second rear end accident 3 months later that Mr. Boo was in. And we contend that we were trying to offer that evidence of that second collision to show that Mr. Boo is a serial plaintiff. He made a claim in that case, just like he made a claim in this case. It shows a pattern of behavior, a modus operandi, if you will. And Mr. Boo testified that he couldn't distinguish the injuries from the first and second accident. The court excluded any evidence or mention of the second rear end accident. Clearly, that was really one of the defenses we were raising in this case, is that, look, this guy's a serial plaintiff. He's gotten rear-ended within 3 months again, and he was making claims again, and he couldn't tell the difference between the damages and the injury he sustained the first time and the injury he sustained the second time.
But even if we were to say that 2 instances show us a pattern, how do we have enough information in the record before us to compare those two collisions to even be able to reach what you're asking us to reach?
I think there is evidence in the transcript itself and evidence in the motions itself of the second accident. The circumstances are similar. The injuries sustained are similar, almost identical. Soft tissue injuries in both cases. So I think given the circumstances of the second injury and its proximity to the first accident, I think you've got enough there to draw the line from A to B.
Can we look at the injuries in that second accident if he has limited his claim for damages to only that time period that covered that first accident? Can we look at that second accident in terms of damages?
I think you could have, if the plaintiff in this case had testified that he could distinguish between the injuries sustained in the first accident and the injuries sustained in the second accident. But remember, he didn't. He testified he could not distinguish between those injuries. And so merely saying, well, we're not going to seek any damages from this point onward, that does nothing to address the serial plaintiff aspect of the defense we were raising, number one. But number two, he couldn't testify or distinguish damage from accident number one versus damage for accident number two. So in that particular situation, if he could say he could distinguish, then I think he might have a point.
So is the argument that the damage calculation must then be wrong because possibly injuries involved crash number two?
Correct.
Or, okay, that, and also that you wanted this sort of affirmative defense or?
Yes. So I think it goes directly to the affirmative defense of the serial plaintiff. One of the other issues we intend to raise was the failure to declare a mistrial with regard to the juror number 4 statement. Here, juror number 4 blurts out and accuses me of doing something to his family. It was done in open court in front of the entire jury panel. We asked for an immediate mistrial and a new panel, which was denied. And the old adage that you never get a second chance to make a first impression, I think that's doubly true with the jury. And in this particular case, that request was overruled, the same panel stayed, and that damage was done. So I think that's error as well.
And you're actually at time now, but did you then, and I know this is in the transcript and I could look, but then were you lead counsel for the entirety of the trial?
Yes. Yes. And the only other argument I would make, Your Honor, was the error in instruction. And there are 4 instructions that we sought to have introduced. All 4 were denied. PIC 121.21 was offered, no person shall stop, stand, or park vehicles on the right-of-way of a controlled access highway. The court had excluded that instruction because he said, well, he didn't stop, but he basically came to almost a stop in front of a 75,000-pound crane coming downhill on 635.
With these errors, would you then need to show prejudice from those errors?
Correct. And the idea here is that these instructions, and I think the standard for jury instructions, the court's required to instruct the jury if there is sufficient evidence that would support the instruction.
Sure. Let's get past that and let's go to the prejudice part.
Right.
How do you think you show prejudice in this case?
Because if the jury isn't allowed to determine through one of these instructions or more of these instructions that this plaintiff came to almost complete stop in front of a heavy vehicle on a 65-mile-per-hour highway and in fact caused the accident.
Are you seeking damages?
No, we didn't make any property damage claim at all.
So the outcome would have been how different if you weren't prejudiced by all of these errors?
Well, the outcome, I think, would be the jury would have been able to determine and have an instruction in front of them that, look, if this fellow either came to a complete stop, like we advocated under KSA 8-1561, or he slowed to basically a stop, then that's something the jury should have been able to consider. And that's the prejudice.
No, the outcome would be the prejudice. So
Correct.
Here, what was the outcome of the trial?
The outcome of the trial was the plaintiff was awarded damages. I believe they were awarded, I believe it was $12,000 in damages.
Okay.
Against both Mr. Weekly and Midwest Crane.
And so how would that have been different with the issuance of these instructions? How would that monetary figure have changed?
Well, I think some of that is supposition because we don't know, because the jury wasn't instructed on each of these four instructions at all. They didn't get to consider it.
I understand that. But the question is then how are you prejudiced by them not being able to consider it?
Because the idea is that if they would have been able to consider the actions of Mr. Boo in coming to almost complete stop on a downhill run in front of a crane and causing an accident, no, we didn't make any claim for property damage, but we were prejudiced because the jury couldn't even consider these items and take them into account and issue a decision in favor of Midwest Crane and Brandon Weekly.
So even though from the plain language of these instructions, they don't apply to your case, you were prejudiced by them not being issued.
Well, I would argue that 3 of the 4 should apply. And the 4th one related to KSA 8-1561, which says, no person shall drive a motor vehicle at such a slow speed as to impede the normal and reasonable movement of traffic.
Okay, so you're going to have to pick your poison.
Yeah.
Did he drive so slow? Or did he come to an almost complete stop? So which of those instructions should have been given?
Well, that's a good point because I argued that it should have been KSA 8-1561. We argued PIC 121.21 about the stopping or parking on an interstate highway, but the court refused it because there was no evidence of an actual full complete stop. But he was going so slowly that it almost basically was a stop. But if they weren't going to give PIC 121.21, they should have at least given a modified instruction on KSA 8-1561, which is the law in Kansas. We would ask that the decision of the trial court be reversed and remanded.
Thank you. And Appellee's counsel, I was pretty generous with the appellant, so you'll have some extra time as well.
Thank you, Your Honor. And I really don't have that much. Because most of our arguments is in our brief. But I do want to correct a few things and put the case in the proper context, which is greatly different than what was offered by the appellant. First of all, my client was from Burma, and unfortunately, he was a naturalized citizen, but we had to have an interpreter all throughout the trial. He speaks a very strong, broken English, and sometimes it can be very difficult to understand. not the easiest case to try. The counsel said, or he mentions in his brief, and he goes on further to give the implication that Mr. Boo all of a sudden slowed down. And this big truck behind him, there wasn't enough space or time for them to prevent an accident. That is not how this case happened. We cited in our brief that when the driver of that truck first saw Mr. Boo, he was 300 yards away, 3 football fields away. He was traveling at that time, and I asked him, 65 miles an hour. By the time he went from 300 yards away to 200 yards away, he has slowed down to 40 miles an hour. He's still 2 football fields away. He says he saw Mr. Booth slowing down then, so he has slowed down to 40 miles an hour. We get to where he is 100 yards, a full football field away. And he says at that time, he has slowed down to about 30 miles an hour. So therefore, there was no abrupt stopping. There was no abrupt movements by Mr. Booth. He'd been watching him for 3 football fields away. And that's the testimony that the jury heard. And the jury didn't buy his arguments. Now, let's go further. To talk about the trooper. Trooper wasn't there. Case law is clear on that. He can't speculate as to what he thought happened. And the part that was kept out, the judge said, I will not allow you to testify as to causation because you were not there. That is proper. And so therefore, the rest of the report was allowed in, just not anything as pertaining to causation. And I don't know if we entered the report, but the report that the judge kept out was that Mr. Boo had abruptly slowed down, which is not the evidence in this case. There was no abrupt stopping. Mr. Boo saw someone else merging in, and he slowed down for the merging. And his testimony was, I go slow. That was what he was saying. The trooper interpreted that was, and I asked him about it, was, well, I thought it could have meant one or two different things. So therefore, well, what the judge did to show this is not an abuse of discretion, the judge allowed the full recording by Officer B's to be played in front of the jury. The jury heard everything that Mr. Boo had said and everything that the other person said. No abuse. The judge let the jury hear everything.
So his body cam, is that
His body cam, the car cam, I believe is what it was, Your Honor. Let him hear, and when he talked to Mr. Boo, when the officer questioned Mr. Boo, everything that Mr. Boo has said was there, recorded, the jury heard it. So the jury didn't have to hear what the officer's interpretation was. The jury heard the live testimony on its own. So the jury could make its decision as to what was and what wasn't, and they didn't buy the argument that was made by the other side. As a matter of fact, the broken English that the jury hit a certain amount of liability Mr. Boo was about a yield sign, because he did not quite understand what a yield sign meant, which is none of his arguments, all right? But that's why the jury did give some liability to Mr. Boo. Let's talk about briefly this testimony by this doing voir dire, which was really not doing voir dire. Now, anyone who's tried a case knows the general rule by most attorneys is you never ask a question that you don't already know what the answer is. That doesn't apply to voir dire because you never know what you're going to hear. I mean, it's fair to everybody across the board. You don't know what these people are going to say. All right? So the judge was actually doing the question. And the judge, this was not improper conduct on the part of the jury. The jury said, judge asked the question, is there a reason why anyone feels they could not fairly sit on this case? He says, raise up his hands. That's proper. He says his first statement was, me and defense counsel don't see eye to eye. There was no further inquiry on that aspect of it. And then he went on to say, a few years ago, he did something to hurt my family. No further inquiries were made. We went up to the bench. The judge, on the judge's own volition, dismissed this juror. No further questions were asked. Different judges would handle this further, different ways. Some judges would hold that juror over and ask further questions to try to find out, what do you mean by what you said? But the judge just dismissed him. Now, it's only in counsel's mind that there's prejudice, because the question is there any reasonable judge that would have done it that particular way? Of course, there are a lot of judges that would have done it exactly that way. Dismiss the person immediately, ask no further questions, which is exactly what took place in this case. So therefore, I think the only thing that lingered was in the mind of the defense counsel. Now, if he really felt there was a prejudice, I don't believe the jury even talked about it. I talked to several of the jurors after the case. He could have talked to a jury and said, was this something that stayed on your mind? This person said something about me? Did y'all talk about that in the jury room? None of that came out. There is no prejudice. He's showing no aspect of prejudice except what is in his head, because it had no bearing on this case whatsoever. No one really cared. Judge handled it correctly. Immediately, it was over. Now, the rest of it again, what is allowed in the court, what is allowed in the way of evidence, instruction as to the duty for looking to your rear. It didn't apply to this case. The judge said, I don't see how this applies. I'm not going to allow it. Still don't know how that would apply, except that this person hit him from the rear. If that's the only criteria that establishes that you have a duty to look to your rear, I don't believe that's what that instruction was designed for. Is if your actions that you are doing would have some impact on those that are behind you, then you have a duty. In other words, you go put your car in reverse, you better turn around and look who's back there. You know, but if it doesn't apply, it doesn't apply. The other arguments the counsel makes pretty much go again to abuse of discretion. There was no abuse of discretion. There was no misinterpretation of the law. There was nothing that was substantially done incorrect by this judge, or something that no other judge would not have done the same way. So therefore, the arguments that counsel's making, we respectfully submit to this court, fall flat on their face. The last argument, and the I believe there was one other argument. The reason I'm doing all this by memory, of course, I left my briefcase in my office. That's my fault. It doesn't do with you, but I remember the case. All right. The arguments that, again, go to abuse of judicial discretion. What's allowed in the evidence? Oh, the motions in limine, again, you have to show abuse of judicial discretion. So the motion in limine, of course, again, goes to the trooper, and that's what the council's bringing out. We talked about the statement that was made by Mr. Ditto, and again, handled properly by the court. We have to go to the instructions that were given, handled properly by the court.
Can I interrupt you for just a second?
Yes.
Was this a one-day trial or two-day trial? 2 days. So there were 2 days between the statement made during voir dire and when the verdict was entered.
Yes, I think that was about the third day. You know, oh yeah, the last argument, and Sorry, he just came and went that fast. The last argument as it pertained to the statement that, serial driver. It's unfortunate that 2 accidents happened within a 90-day period of time. That's an unfortunate situation. But to say they're so close, there's nothing like one accident happens on the other highway, the other accident happens in the city. You know, what's similar about that? One accident because a person is merging in and slows down for a merge, the other accident had nothing to do with a merge. What's the similarity? How is this a serial? Just an unfortunate set of circumstances, 2 accidents. Well, let's make it a serial. Let's talk about the 3rd and the 4th one. Oh my goodness, there wasn't one. This is no serial anything. It's an exaggeration of the facts, the circumstances. We limited the testimony. The doctor who testified as to the injuries and gave the medical bills and talked about the injuries in front of the jury, who was our expert, said, I am limited to this 30-day period of time in which I treated Mr. Boo, and not a day after that. That was the testimony of our expert. The verdict fell within that realm. I have nothing else.
Anything else? No? All right, thank you. Okay, 2 minutes.
Very good. And I'll try to not use all the 2 minutes, which is music to your ears, I'm sure. So couple corrections. One, the recording that was ultimately played for the jury of Trooper B's body cam, it was not actually a body cam. He was wearing a mic, but it was recording from his car. And so it's not like a more of a dash cam than really a body cam. So, and second, it was redacted because there were certain things said in that with regard to insurance. And so it was not a full and complete copy of the recording. So, second, Judge Isherwood, you questioned some of the jury instructions. And I would point to one of them in particular. PIC 121.03 was offered and was refused. This is the lookout instruction, and it requires a lookout to the rear if movement of a vehicle may affect the operation of a vehicle to the rear. Now, you would think a rear end collision, how does that lookout instruction apply? I'll tell you. At the scene, Thang Boo tells Trooper B's that he's looking to the rear right before the collision. He even claims that the driver, Brandon Weekly, is on his phone right before the collision. So the trooper checks the phone of Brandon Weekly and finds that to be no basis in fact at all. But how does that circle back around to PIC 121.03? The testimony was that Boo had slowed to almost a stop with no one in front of him on the highway on a 65-mile-per-hour roadway. The lookout to the rear instruction would have been proper if the movement of his vehicle may affect the operation of the vehicle to the rear. Certainly it did in this case. And so we have testimony from the very plaintiff in this case saying he's looking back and he's claiming the guy's on his phone and he's watching. Well, why is he doing that? You have to wonder. Finally, with regard to the claim of the serial plaintiff, counsel suggests that these accidents are totally different, nothing similar about them at all. Well, one of the accidents was on K-10 highway, a 2-lane highway in each direction that the court is probably familiar with. The other was on Interstate 635, a 3-lane highway, and both were rear-end accidents. So there's more similarity to these accidents than plaintiff's counsel would allow you to believe. So for all of those reasons, we would ask that the court reverse and remand this matter for a new trial consistent with the arguments here today.
On the recording, were the inconsistent statements that are at issue, were those redacted out of the recording?
I don't believe they were redacted, but I would have to check the transcript on that in all candor.
Thank you.
Thank you. We appreciate your time.
Thank you, counsel. This case is now submitted for decision. We'll take it under advisement